Good day, everyone! Today's discussion is all about Law of Corporation, Title 5, 6, and 7.
Title 5, Bylaws.
Section 46, Adoption of Bylaws. And Section 46 enables the adoption and filing of bylaws prior to incorporation, provided that they are approved by all incorporators and submitted to the Securities and Exchange Commission along with the Articles of Incorporation. The necessity of bylaws. The corporation must adopt the Code of Bylaws for its eternal government. Corporation has inherent power to adopt bylaws, one of its legal antecedents, and is usually expressly granted by law of the charter, subject to limitation as may be contained in the statute or constitution and the general requirements of validity. If a corporation fails to file its bylaws, its certificate of incorporation may be suspended or revoked. Bylaws cannot provide for unreasonable restriction. Restrictions on trading stocks must be derived from legislative enactment. As the corporation cannot create such barriers, bylaws are made to protect people, not to limit them. Bylaws validity. As a general rule, a corporation bylaws are valid if they are reasonable and calculated to carry out the corporation's objectives and are not consistent with the general policy of the legal provisions. Binding effect of bylaws. Bylaws are effectively written into the contract and become part of the corporation's fundamental law, and the corporation, as well as its directors and officers, are bound by them and must follow them. Strangers, on the other hand, are not required to understand bylaws, which are merely provisions for the administration of the corporation.
Section 47. Contents of Bylaws. Subject to the provision of the Constitution, this code, other special law, and the Articles of Incorporation, a private corporation may provide its bylaw. In this section, a private corporation may provide bylaws. So the contents of bylaws are: first, the time, place, and manner of calling and conducting regular or special meetings of the directors or trustees. Second, the time and manners of calling and conducting regular or special meeting of the stockholders or members. Next is the required quorum in meeting of stockholders or members and the manner of voting therein. Fourth is the form of proxies of stockholders and members and the manner of voting them. The other contents of bylaws are the qualifications, duties, and compensation of directors or trustees, officers, and employees. The time for holding the annual election of directors or of trustees and the mode or manner of giving notice thereof. The manner of election or appointment and the term of office of all officers other than directors or trustees. The penalties for violation of the bylaws. In this case, the stock corporation, the manner of issuing stock certificates, and such other matters as may be necessary for the proper or convenient transaction of its corporate business and affairs. Bylaws signifies the rules and regulation or private laws enacted by the corporation to regulate, govern, and control its own actions, affairs, and concern and its stockholders of member and directors and officer with relation thereto and among themselves in the relation to it. So bylaws are relatively permanent and continuing rules of action, right and duties of corporations officers and directors, trustees, or stockholders or members towards the corporation. So in other words, it is a duties of the members towards corporation and among themselves. Distinguish bylaws and articles of incorporation. Bylaws is condition subsequent. Its absence merely furnishes a ground for the revocation of the franchise or certificate of registration, while articles of incorporation is a condition precedent in the acquisition of corporate existence. The rules and regulation of bylaws adopted by the corporation. while the Articles of Incorporation constitute the character or fundamental law of the corporation. Bylaws executed before or after incorporation. The Articles of Incorporation executed before incorporation. The Articles of Incorporation is amended by the majority of the Board of Directors or trustees and stockholders representing two-thirds of the outstanding capital stock, two-thirds of the member in cases of non-stock corporation. In bylaws, it may be amended by a majority vote of the Board of Directors and majority votes of the outstanding stock or majority of the members in a non-stock corporation.
Section 48, Amendments to Bylaws. Amendment and repeal of bylaws and adoption of new bylaws. Power implied. The power to make bylaws implies the power to alter or repeal them and enact new ones. But the power to alter bylaws or adopt new bylaws has the same limits as the power to make them in the first instance. Formalities. Section 48 provides the formalities to be followed in making amendment or repeal of bylaws or in adopting new bylaws. The bylaws may provide for a greater number of votes. In all cases, the power can only be exercised at a regular or special meeting duly called for the purpose. Even holders of non-voting shares or non-voting members, as the case may be, are entitled to vote on the matter. Delegation of power. The power may be exercised by stockholders or members directly or indirectly by delegating said power to the board of directors or trustees. However, it has been held that the authority given to the board of directors or trustees. However, it has been held that the authority given to the board of directors to alter or amend bylaws must be so construed as to restrict it from altering or annulling a bylaw imposing a limitation on its power. Lesser number of votes required to revoke the delegated power to amend or repeal the original bylaws. The law merely requires the vote of stockholders representing a majority of the outstanding capital stock or a majority of the members, as the case may be, while the vote for delegation is two-thirds. The evident purpose of the law is to make it easier to revoke the delegated power as a safeguard against possible abuse of the power by the board of directors or trustees.
Is Title 6 Meetings. Now in Section 49, it furthers the discussion and concept of meetings when it comes to the concept of corporation. Section 49 provides different kinds of meetings in the corporation. Now, the meetings of directors, trustees, stockholders, or members may be regular or special. So from that alone, as you can read or see, there are also two kinds of meetings, special and regular. Meetings of stockholders or members, it may be irregular or those held annually on a date fixed in the bylaws or even not so fixed on any date after April 15 of every year as determined by the board of directors or trustees. It is held principally for the purpose of electing another set of directors or trustees. Or special or those held at any time deemed necessary or as provided in the bylaws. Meetings of directors or trustees, it may be irregular or those held by the board monthly unless by the bylaws provided otherwise, or special or those held by the board at any time upon the call of the president or as provided in the bylaws.
Section 50, Regular and Special Meetings of Stockholders or Members. Regular meetings of stockholders or members shall be held annually on a date fixed in the bylaws, or if not so fixed, on any date in April of every year as determined by the Board of Directors or Trustees, provided that written notice of regular meetings shall be sent to all stockholders or members of record at least 2 weeks prior to the meeting, unless a different period is required by the bylaws. Special meetings of stockholders or members shall be held at any time deemed necessary as provided in the bylaws, provided, however, that at least 1 week written notice shall be sent to all stockholders or members unless otherwise provided in the bylaws. Notice of any meeting may be waived expressly or impliedly by any stockholder or member. Whenever, for any cause, there is no person authorized to call a meeting, the Securities and Exchange Commission, upon petition of a stockholder or member on a showing of good cause, therefore, may issue an order to the petitioning stockholder or member directing him to a meeting of the corporation by giving proper notice required by the or by the bylaws. The petitioning stockholder or member shall preside thereat until at least a majority of the stockholders or members present have chosen one of their number as presiding officer. Kinds of meetings are regular and special. Stockholders and directors. The stockholders are given notice of the resolution by the Secretary of the Corporation. Directors passes a resolution declaring payable the whole or certain percentage of the unpaid subscription, stating the date fixed for payment. If the date of payment is specified in the contract of subscription, no call is necessary.
Section 51. Place and time of meetings of stockholders or members. The proper place of the meetings, either regular or special, of stockholders or members, happen in the city or municipality where the principal office of the corporation is located, and if practicable in the principal office of the corporation, provided that Metro Manila shall, for purposes of this section, be considered a city or municipality. Notice of meetings shall be in writing, and the time and place thereof stated therein. So that means that all the announcements are written in the notice containing the time and place of the meetings, and this will be used for informing the stockholders or members of the meeting. All proceedings had and any business transacted at any meeting of the stockholders or members, if within the powers or authority of the corporation, shall be valid, even if the meeting be improperly held or called, provided all the stockholders or members of the corporation are present or duly represented at the meeting. So if the meeting is improperly held or convened, they don't care as long as they can have the meeting and all the stockholders or members of the corporation are present, and as long as every one of them agreed.
Section 52, Quorum in Meetings. So a quorum is a minimum acceptable number of individuals with a vested interest in a company needed to make sure the proceedings of a meeting valid. So unless otherwise provided for in this code or in the bylaws, a quorum shall consist of the stockholders representing a majority of the outstanding capital stock or a majority of the members in the case of non-stock corporations. So the purpose is to ensure that a corporation's shareholders are adequately represented at a meeting where changes will be made to the company.
Section 53, Regular and Special Meetings of Directors or Trustees. Regular meetings of the Board of Directors or Trustees of every corporation shall be held monthly, unless the bylaws provide otherwise. Special meetings of the Board of Directors or Trustees may be held at any time upon the call of the President or as provided in the bylaws. Meetings of directors or trustees of corporations may be held anywhere on or outside of the Philippines, unless the bylaws provide otherwise. Notice of regular or special meeting stating the date, time, and place of the meeting must be sent to every director or trustee at least 1 day prior to the scheduled meeting, unless otherwise provided by the bylaws. A director or trustee may waive this requirement in either expressly or impliedly. Regular meetings, it is monthly because they are the governing bodies of the corporation. They are the ones who basically run it, so they need to be there always and should hands-on in their work. Meetings. of directors or trustees of corporations may be held anywhere in or outside of the Philippines unless the bylaws provide otherwise. Our bylaws just say that our meeting is only held outside the Philippines. It's good. Or if the bylaws say that our meeting is only in the Philippines, it's still good. Notice of regular or special meeting stating the date, time, and place of the meeting must be sent to every director or trustee at least 1 day prior to the scheduled meeting unless otherwise provided by the bylaws. Because maybe even the stockholders or members of the corporation owners, we have a board of directors or trustees because we need a compact body to govern the corporation for the sake of efficiency. As you can see here, at least 1 day prior to the scheduled meeting or unless the longer time is provided by law.
Section 54. Who shall preside at meetings? The President shall preside at all meetings of the directors or trustees as well as of the stockholders or members, unless the bylaws provide otherwise. The fact that a director is at the same time the presiding officer of the meeting does not deprive him of the right to vote as such director. He cannot be deprived of the right by a majority vote of its board without his consent. Regular and special meetings of directors and trustees. Place of meeting. Meetings of directors or trustees may be held at any time specified in the bylaws, unless the bylaws provide otherwise. Notice of regular or special meetings of directors or trustees must be sent to them at least 1 day prior to the scheduled meeting.
Section 55. Right to vote of pledgors, mortgagors, and administrators. So, the right to vote of secured creditors and administrator in case a stockholders grant security interest in his or her shares in the stock corporation. So, you gave authority to the creditors on your right to vote as a shareholders of this particular corporation. So, the stockholder grantors have a right to attend and vote at meeting of the stockholders. For example, you make your share as collateral in the corporation. Remember, your share is your ownership in the corporation. So, pledger or mortgage shall have the right to attend and vote at meeting of stockholders.
Section 56. Voting in case of joint ownership of stock. In case of shares of stock owned jointly by 2 or more persons, in order to vote the same, kinakailangan yung consent of all the co-owners. Unless there is a written proxy which is also signed by all the co-owners of the joint ownership of stock, authorizing one or some of them or any other person to vote such share or shares. Provided that when the shares are owned, kung napasa kanila na yung share, pwede itong magamit ng kahit na sino na part of all the co-owners of the joint ownership para bumoto or appoint a proxy or substitute therefore.
Sections 57. Voting right for treasury shares. Treasury shares shall have no voting right as long as such shares remain in the treasury. So, as you can see, no, si treasury share walang voting right.
Section 58. Proxies. So when we say proxy in corporate law, it is a person who votes for and this represents the stockholders or members. So how does voting by proxy happens? Ordinarily, the right to vote shall be exercised by the stockholders themselves or by their duly authorized representatives. Proxy to be valid must be first in writing, signed by the stockholder or member giving it, then signed and filed by the stockholder or member in any form authorized in bylaws and received by the corporate secretary within a reasonable time before the scheduled meeting. Then, it is valid only for the meeting for which it is intended unless otherwise stipulated. And then, even if the proxy is a continuing one, it shall not be longer than 5 years at any one time. So for example, the proxy is 10 years. So only the 5 years in that 10 years is valid.
Section 59, Voting Trust. One or more stockholders of a stock corporation may create a voting trust for the purpose of conferring upon a trustee or trustees the right to vote and other rights pertaining to the shares for a period not exceeding 5 years at any time, provided that in the case of a voting trust specifically required as a condition in a loan agreement, said voting trust may be for a period exceeding 5 years but shall automatically expire upon full payment of the loan. A voting trust agreement must be in writing and notarized and shall specify the terms and conditions thereof. A certified copy of such agreement shall be filed with the corporation and with the Securities and Exchange Commission. Otherwise, said agreement is ineffective and unenforceable. The certificate of certificates of stock covered by the voting trust agreement shall be concealed, and new ones shall be issued in the name of the trustee or trustees stating that they are issued pursuant to said agreement. In the books of the corporation, it shall be noted that the transfer in the name of the trustee or trustees is made pursuant to said voting trust agreement. The trustee or trustees shall execute and deliver to the transfers voting trust certificates which shall be transferable in the same manner and the same effect as certificates of stock. Distinguish proxy from voting trust. Proxies shall in writing signed by the stockholder or member and filled before the scheduled meeting with the corporate secretary. Unless otherwise provided in the proxy, it shall be valid only for the meeting for which it is intended. However, no voting trust agreement shall be entered into for the purpose of circumventing the law against monopolies and illegal combinations in restraint of trade or use for purposes of fraud. Unless expressly renewed, all rights granted in a voting trust agreement shall automatically expire at the end of the agreed period, and the voting trust certificates, as well as the certificates of stock in the name of the trustee or trustees, shall thereby be deemed cancelled, and new certificates of stock shall be reissued in the name of the transferors. The voting trustee or trustees may vote by proxy unless the agreement provides otherwise. Individual suit. When a wrong is directly inflicted against a shareholder, the latter can maintain an individual or direct suit in his own name against the corporation. Stockholders' individual suit is therefore an action brought by a stockholder against the corporation for direct violation of his contractual rights as such individual stockholder, such as the right to vote, the right to share in the declared dividends, the right to inspect corporate books and records, and similar other examples. Representative suit. When a wrong is committed against a group of stockholders, a stockholder may bring a suit in behalf of himself and all other stockholders who are similarly situated. This is called a shareholders' representative suit, which is a kind of class action. It saves the persons involved in the action substantial time and money. Derivative suit. If the injury is one to the plaintiff, a stockholder or member, and to him individually, and not to the corporation, as where the action is based on a contract to which he is a party, or on a right belonging severally to him, or on a fraud affecting him directly, it is an individual action. On the other hand, if the wrong is primarily against the corporation, the redress for it must be sought by the corporation, except where a derivative action by a stockholder is allowable and the stockholder cannot sue as an individual.
Title 7. Stocks and Stockholders.
Section 60. Subscription Contract. Any contract for the acquisition of an issued stock in an existing corporation or a corporation still to be formed shall be deemed a subscription within the meaning of this title, notwithstanding the fact that the parties refer to it as a purchase or some other contract. In a stock corporation, it talks about having stocks which the shareholder must own. A person may become a shareholder by subscription contract with an existing corporation for the acquisition of unissued shares, by purchase from the corporation of treasury shares, by transfer from a previous stockholder of the outstanding shares or existing subscription to shares. Binding effect of subscription. No person can become a shareholder in a corporation unless there is a valid contract between him and the corporation. No express promise to pay is necessary to make the subscriber liable. When a contract of subscription for the stock is binding, it is a contract between the subscriber or subscribers and the corporation. No form required of subscription contracts. A stockholder is a person who accepts a certificate of stock from a corporation or who acts as a stockholder by participating in stockholders' meetings, making payments, or otherwise. They are liable as such to creditors and also to the corporation, although there may have no express contract of subscription. Sale of shares of stock needs Security Exchange Commission approval. The Philippine Securities and Exchange Commission has issued an exemption from the requirements of registration and licensing for companies that issue share or bonds. The exemption is in the form of a resolution by the way of resolution and comes from the SEC's Board of Directors. Power to issue shares is lodged in the Board of Directors and no stockholders meetings is necessary. Additional issuance of shares of stockholder does not need approval of the stockholders. The Board of Trustees shall prescribe the form of the certificate of the stock on corporation.
Kinds of subscription. Free incorporation is one that was agreed upon prior to the proposed corporation's incorporation. Post-incorporation subscription after the corporation's incorporation or formation. Absolute subscription, one who is not subject to any condition or the occurrence of certain unknown events. Conditional subscription. The subscription of a subscription does not make the subscriber a stockholder or render him liable to pay the amount of subscription until performance or fulfillment of the condition. Its fulfillment depends upon the happening of uncertain events of contingencies and may vary from time to time. Subscription upon special terms, where the corporation agreed as an independent element to do a certain things or things but not as condition to the annual of liability of the subscriber or the acquisition of the rights of a stockholder.
Section 61. Pre-incorporation subscription. Are corporation that's still to be formed that has subscription of shares. In this section, the subscription of shares are irrevocable for at least 6 months, meaning you cannot change or recover unless the other give consent, the revocation or corporation fails to incorporate within the same period, or within a longer period stipulated in the contract of subscriptions. Those are the steps to consider when it comes to revocation of the subscription of contract. Remember, no pre-incorporation subscription may be revoked after the articles of incorporation is submitted to the Commission.
Revocability of pre-incorporation subscription contract. Conditions for revocation. Section 61 prescribes the conditions for revocation of pre-incorporation subscription contract either by the subscriber or the corporation.
when irrevocable. The subscription is irrevocable for a period of at least 6 months from the date of subscription, notwithstanding any agreement to the contrary, except in the 2 instances mentioned. In any case, it cannot be revoked after the submission of the Articles of Incorporation to the Commission, although beyond the 6 months period. Reason for irrevocability. The irrevocability of pre-incorporation subscription contracts prevents a subscriber from speculating on the stocks of a proposed corporation. Furthermore, it is to the interest of each subscriber that the others are bound by their subscriptions, and the new corporation should have as operating capital enforceable subscriptions. Thus, the rule protects the corporation from financially irresponsible subscribers.
Effects of filing of Articles of Incorporation. The subscriber is not bound indefinitely, for the period of irrevocability is limited. After submission of the Articles of Incorporation to the Security and Exchange Commission, a pre-incorporation subscription may no longer be revoked, although the period of 6 months has already elapsed. Upon incorporation of a corporation, both the incorporators, who are signatories of the Articles of Incorporation, and subscribers automatically become shareholders. The subscription, which until that time was merely an offer, become a binding contract from which the subscriber cannot withdraw, except in the case of fraud or other matters which may operate to discharge him from liability on his subscription.
Section 62, Consideration of Stocks. A stock is the ownership in the corporation, and it shall not be issued for a consideration less than the par or face value or its issued price thereof. So when stocks are issued with a corporation, consideration may be any or a combination of any 2 or more of the following. So first, we have the actual cash na ibinayad sa corporation. Second, property, tangible or intangible na na-receive ng corporation. It will undergo a fair valuation so to identify kung equal ba to the par value of the stock issued yung property, tangible or intangible asset na na-receive ni corporation. Third, labor performed or services rendered to the corporation. Fourth, yung previous na mga utang ni corporation. Fifth, amounts na na-transferred mula sa unrestricted retained earnings to stated capital. 6. Outstanding shares na in exchange for stocks in the events of reclassification or conversion. So when we say conversion, it means change in form, appearance, or use. Consideration for intangible property. So, yung mga patents of copyright, like say for example, so the valuation thereof shall initially be determined by the incorporators or the board of directors or trustees. And after that, it will be subject to approval by the Securities and Exchange Commission or SEC. So, shares of stock shall not be issued in exchange for promissory notes or future services. So, ibig sabihin, hindi pwedeng utangin yung shares of stock or bibili ka ng shares sa isang kumpanya and then pagtatrabahuan mo ito in exchange of the price of that share that you purchased. Next, the same consideration provided for in this section may be used for the issuance of bonds by the corporation. The issued price of no par value share or yung shares with no face value may be fixed in the Articles of Incorporation or by the Board of Directors pursuant to authority conferred upon it by the Articles of Incorporation or the bylaws. But if it's not stated, a meeting duly called for the purpose will take place and the stockholders representing at least a majority of the outstanding capital stock should be there for the act to be valid.
Section 63, Certificate of Stock and Transfer of Shares. The capital stock of stock corporation shall be divided into shares for which certificates signed by the President or Vice President, countersigned by the Secretary or Assistant Secretary, and sealed with the seal of the corporation shall be issued in accordance with the bylaws. Shares of stock so issued are personal property and may be transferred by delivery of the certificate or certificates endorsed by the owner or his attorney in fact or other person legally authorized to make the transfer. No transfer, however, shall be valid except as between the parties until the transfer is recorded in the books of the corporation showing the names of the parties to the transaction, the date of the transfer, the number of the certificate or certificates, and the number of shares transferred. No shares of stock against which the corporation holds any unpaid claim shall be transferable in the books of the corporation.
Section 64. Issuance of stock certificates. So what is this certificate of stock? It is a written instrument signed by the proper corporate officers and evidencing the fact that the person therein named is the registered owner of the share or shares therein described. So according to Section 64, no certificate of stock shall be issued to a subscriber until the full amount of his subscription together with interest and expenses in case of delinquent shares, if any is due, has been paid. So it is prohibited to issue certificates of stock to a subscriber who has not paid the full amount of his subscription together with interest and expenses. Under Section 64, there are three types of suits mentioned: the derivative suit, individual suit, and representative suit. For derivative suit, one brought by one or more stockholders or members in the name and in behalf of the corporation to redress wrongs committed against it or to protect or vindicate corporate rights. For individual suit, one brought by a stockholder in his own name against the corporation for direct violation of his contractual rights, such as right to vote, to dividends, etc. And for representative suit, group of stockholders may bring a direct suit against the corporation. This is when a wrong is committed against a group of stockholders. So to sum it up, in derivative suit, the wrongdoing was caused to the corporation. And for the individual suit, the wrongdoing caused to the individual stockholder or individual member. And for the representative suit, the wrongdoing was caused to a group of stockholders.
Issuance of stock certificate, it requires first, signed by the president or vice president, countersigned by the secretary or assistant secretary, and sealed with the seal of the corporation and issued in accordance with the law. Second, the certificate must be delivered or mailed to the subscriber with the documentary stamps required by the law affirmed thereon. Third, the par value with respect to shares with par value or the full subscriptions as to no par value shares must be fully paid. Fourth, where it involves transfer of outstanding shares, the original certificate must be retained. Purpose of registration of transfer. First, to enable the corporation to know at all times who its actual shareholders are, because mutual rights and obligations exist between the corporation and its stockholders. Second, to afford to the corporation an opportunity to object or refuse its consent to the transfer in case it has any claim against the stock sought to be transferred or for any other valid reason. Third, to avoid fraudulent or fictitious transfer. Fourth, it is intended also for the benefit and protection of persons who may deal with the corporation and become creditors so that they know who are the stockholders and as such liable to its creditors.
So the following are the right to transfer shares of stock. So first is by delivering the certificate duly endorsed on the back. Second, by delivering the certificate accompanied by a separate assignment. And third, where stock is levied on in execution of judgments, by delivering the certificate coupled with an assignment by the sheriff who conducted the levy. Then lastly, transfer by sale of delinquent shares.
Section 65, liability of directors for watered stocks. So when we say watered stocks, this is an illegal scheme to defraud investors by offering shares at deceptively high prices. So basically, watered stock is an illegal act and it creates liability for investors. So any director or officer of a corporation consenting to the issuance of watered stocks shall be liable together with the stockholder concerned to the corporation and its creditors for the difference between the fair value received at the time of issuance of the stock and the par or issued value of the same.
Section 66. Interest on unpaid subscription. Subscribers for stock shall pay to the corporation interest on all unpaid subscriptions from the date of subscription if so required by, and at the rate of the internet is fixed in the bylaws, such rate shall be deemed to be the legal rate. The interest on subscription will now be stated in the subscription contract according to the law. Provides that the interest on subscription will now be stated in subscription contract. Liabilities of stockholders. Liability to the corporation for unpaid subscription. Liability to the corporation for interest on unpaid subscription. Liability to creditors to the corporation on unpaid subscription. Liability for watered stock. Liability for dividends unlawfully paid. Liability for failure to create a corporation. Liabilities of subscribers to the corporation.
Section 67. Payment of balance of subscription. Remedies to enforce payment of stock subscription. Extrajudicial sale at public auction permits the corporation to put up unpaid stock for sale and dispose of it for the account of the delinquent subscribers. Judicial action by court action. Denying a stockholder delinquent for unpaid subscription the right to vote. Collection from cash dividends and withholding stock dividends. Sanctions on stock delinquent. Rights denied to stockholders shall not be voted or be entitled to vote or representation at any stockholders' meeting, nor entitled the holder thereof to any of the rights of a stockholder except the right to dividends. Right given to the corporation. The corporation has the right to apply cash dividends due on delinquent stock, the unpaid and balance on the subscription plus cost and expenses. While stock dividends, corporation to withhold the same from the delinquent stockholder until his unpaid subscription is fully paid. When is the balance of subscription payable? On the date specified in the contract of subscription. In the absence of any specified date in the contract of subscription. On the date stated in the call made by the board of directors. When does the stock become a delinquent? Stock becomes delinquent upon failure of the holder to pay the unpaid subscription or balance thereof within 30 days from the date specified in the contract of subscription or on the date stated in the call. A declaration officially made by a corporation usually expressed in the form of a resolution of the board of directors requiring payment of all or a certain prescribed portion of a subscriber's stock subscription. Requisites for a valid call. It must be made in the manner prescribed by law. It must be made by the board of directors. It must operate uniformly.
Section 68, Delinquency Sale. The Board of Directors may, by resolution, order the sale by delinquent stock and shall specifically state the amount due on each subscription plus all accrued interest and the date, time, and place of the sale, which shall not be less than 30 days nor more than 60 days from the date the stocks become delinquent. Notice of sale with a copy of the resolution shall be sent to every delinquent stockholder either personally or by registered mail. The same shall furthermore be published once a week for 2 consecutive weeks in a newspaper of general circulation in the province or city where the principal office of the corporation is located.
Call.
A declaration officially made by a corporation, usually expressed in the form of resolution of the board of directors requiring payment of all or a certain prescribed portion of a subscriber's stock subscription. Effect of delinquent sales cannot be voted for or be entitled to vote in corporate meetings or be represented by proxy at the stockholders' meeting. Second, the holders of delinquent stock is not entitled to exercise the right of a stockholder, example, to inspect book and records. Third, the holder of delinquent stock is entitled to dividends. However, that any cash dividend due on delinquent stock shall first be applied to the unpaid balance on the subscription plus cost and expense, while stock dividends shall be withheld from the delinquent stockholders until his unpaid subscription is fully paid.
Highest bidder. The person offering at the sale to pay the full amount of the balance on the subscription together with accrued interest, cost of advertisement and expenses of sale. For the smallest number of shares, in the absence of bidders or highest bidder, the corporation may purchase for itself the delinquent stock.
Section 69. When sale may be questioned. No action to recover delinquent stock sold can be sustained upon the ground of irregularity or defect in the notice of sale or in the sale itself of the delinquent stock, unless the party seeking to maintain such action first pays or tenders to the party holding the stock and the sum for which the same was owed, with interest from the date of sale at the legal rate, and no such action shall be maintained unless it is commenced by the filing of a complaint within 6 months from the date of sale. Basically here, there is a certain person questioned the validity of sale of delinquent stock. For example, that person is one of the bidders of public auction wherein public stock is sold. Then he lose and noticed that there might be irregularity in the selling happened. With that, he can question about that. However, he cannot question unless the party seeking to maintain such action first pays or tenders to the party holding the stock the sum for which the same was sold, with interest from the date of sale. That is why they need to pay first the bidder who hold the stock before he will file action during the delinquent stock sold. But after 6 months from the date of sale, he cannot file the action. It should be within 6 months. And the grounds for the recovery of stock unlawfully sold for delinquency are: first, irregularity or defect in notice of sale. Then second, irregularity or defect in the sale itself of the delinquent stock.
Section 70. Court action to recover unpaid subscription. Nothing in this code shall prevent the corporation from collecting by action in a court of proper jurisdiction the amount due on any unpaid subscription, with accrued interest, cost, and expenses. There are 3 ways of corporation to the unpaid subscription: the extrajudicial sale through a public auction, autonomous judicial action, and the cash dividends. Just apply that to the unpaid portion, then the stock dividends it will be healed. That is the action or remedies that can be done of the corporation. So, in Section 70, these are the instances where instead of public auction, the delinquent stocks in delinquent description, instead sell it to the public auction, the board of directors says don't do that. Let's first compel the delinquent stockholder to pay for his subscription. If the delinquent stockholder doesn't want to pay his subscription, the board of directors they can go to the court so that the court will compel the delinquent stockholder to pay his unpaid subscription. So this is the judicial remedy. The board of directors will decide instead of their public auction, they will just compel the delinquent stockholder through a court to pay his unpaid subscription.
Section 71. Effect of delinquency. No delinquent stock shall be voted for or be entitled to vote or to representation at any stockholders' meeting, nor shall the holder thereof be entitled to any of the rights of a stockholder except the right to dividends in accordance with the provisions of this code until and unless he pays the amount due on his subscription with accrued interest and the cost and expenses of advertisement, if any. Section 71 stock delinquency does not deprive the holder of all his rights as a stockholder except the right to be voted for or be entitled to representation at any stockholders meeting. He shall still receive dividends, but delinquent stock shall be subject to delinquency sale.
Section 72. Rights of unpaid shares. Holders of subscribed shares not fully paid which are not delinquent shall have all the rights of a stockholder. In Section 72, prior to the delinquency of unpaid shares, the holder is not considered to have violated any contract with the corporation and thus he has all the rights of a stockholder including the right to vote.
Section 73. Lost or destroyed certificates. In this section, this is a procedure if the certificate lost. Remember, if the certificate of stock lost, it doesn't mean you lost the ownership of the corporation because stock certificate is an evidence.
Instances when new certificate issues. The issuance of a new stock certificate shall be put on hold if contest has been presented to the corporation or if an action is pending in a court regarding the stock certificate is questioned. This suspension will only be lifted once the court makes its final decision regarding the said stock certificate. If the corporations follow the necessary step in issuing replacement stock certificate, then no action can be brought against them. Expectation to this are cases of fraud, bad faith, or negligence on the part of the corporation and its officers.